位委員。
Members, it's time and we have a quorum. I call to order the meeting. Item on the agenda, there's just one today. That is for the Secretary for Justice to brief this panel on the policy initiatives of the Department of Justice. Members, please take your seat in accordance with the seating plan for the House Committee. For members of this panel and members of the Council who wish to speak, please press the Request to Speak button, because we expect large number of members wishing to speak. So for efficiency, I would propose that members press the Request to Speak button. First of all, I will invite the Secretary for Justice to speak before I invite members to speak. When can members press the button?
司長入嚟就撳得掣，定係而家撳得掣？嚇，咁咧就而家大家已經可以撳掣㗎啦嚇。如果想發問嘅，撳得未啊？撳得啦嚇。咁咧就此外請大家肅靜嚇。我喺今日開會之前呢，就收到副主席郭榮鏗議員同埋楊岳橋議員就議程項目1係提交議案。咁呢個呢，我會喺委員提問之後先至處理嘅。咁應該處理嘅時間呢，就係6點半之前。我亦都想提醒各委員，如果你哋認為合適，就應該根據議事規則第8。
Members, if you please go by Rule 83A and 83 Rule in relation to declaration of interest, and also on you must please note the voting arrangement as where appropriate. Now today's meeting is for the Secretary for Justice to brief this panel on her work. Can we invite the Secretary for Justice to join us, please?
可能司長喺出邊係咪都會有一啲
I think the Secretary, or can I ask the staff to find out whether the Secretary for Justice is going to join us soon? Please give her assistance so she could join us soon. May I also say this? Because there is a large number of members who wish to speak, so I would draw the line now for members who've already pressed the button. And if there is still time left, and I see that I could allow more members to speak, then I'll allow more members to speak. So please press the button as soon as possible. After you've pressed the button, the clerk will do a count, and then I'll draw the line here, because I would like to allow members sufficient time for exchanges with the Secretary for Justice. So can we invite the Secretary to join us, please? Secretary, please. Now, because many members wish to ask questions today, so I'd like to make the most of the time we have. Can I now invite the Secretary for Justice, Ms. Teresa Zhang, to briefly take us through the paper. The paper has been forwarded to members beforehand. So members, please refer to the paper as you ask questions. Secretary for Justice, please. SJ. Madam Chair, first of all, I would like to thank you and the Secretariat for making this arrangement so that shortly after I assume office, I'm able to attend a meeting of the Administration of Justice and Legal Services Panel, so I could brief members on the 2018 policy initiatives of the Department of Justice. The Department of Justice has the duty to defend the rule of law in Hong Kong, including judicial independence. In accordance with the basic law and other relevant legislation, the DOJ also provides legal advice to various policy bureaus and departments and also we give advice on ways to handle legal proceedings. This is to make sure that prosecution work is taken out in a fair and impartial manner. We must also go by Article 63 of the Basic Law and act in accordance with that article. We must also make sure that government's legislation is easy to understand and access. And Hong Kong, we also want to consolidate Hong Kong's position and competitiveness as a leading international legal and dispute resolution services center in the Asia-Pacific region. For the various 2018 policy initiatives of the Department of Justice, they have been spelled out in the paper submitted to the panel. I do not propose to go into details of the paper, but I would like to highlight a few points. First of all, about developing Hong Kong into a leading international legal and dispute resolution service center in the Asia-Pacific region. There are 3 points here. First, locally, we would like to make the most of our advantage for younger and junior legal personnel. They could have more opportunities to take part in legal and dispute resolution services. This will ensure continuous development locally and sustainable development locally. Now, very often when we talk about taking the first step, we will consider at the policy level whether we could set up any pilot schemes. So for the less experience of those with who are more junior would be able to join the profession sooner, and so they could accrue more experience in arbitration and resolution and so on. And then at an international level, of course, our professional need to upgrade themselves and enhance their knowledge. So how are we going to promote that? There are many legal professionals doing promotion outside of Hong Kong. We must keep up that effort. My own experience that every year or every other year we have to repeat promotional efforts at the same place. And at the same time, we would like to bring major international conferences to Hong Kong. Now, sometimes, of course, we make an effort to promote Hong Kong overseas, but it's actually more effective for people to come to Hong Kong to see how things are working here. And the third point is about the mainland. The mainland enterprises are becoming more and more internationalized, and that's the Belt and Road Initiative. The enterprises already are going global, so we can see how we could leverage on Hong Kong's unique advantage to help these enterprises develop further through Hong Kong. Now, we can have regard to the Belt and Road Initiative and the flexibility of this initiative, so we can see how we can make use of the flexibility and the convenience of this initiative to further promote our services. So if there is time, I could speak in more detail on that. The second point I'd like to highlight is this. For civil and the reciprocal arrangement on civil and commercial matters. Now we have already reached an agreement, but I understand lawyers have made various requests. So from the professional point of view, there is need to provide to achieve certain outcome in mutual legal assistance. I hope we could proceed with that as soon as possible. But we need to listen to the views of the sector so we could make set priorities, and then together with the various bureau departments and even ministries on mainland, we could pass on the views of the profession. Now, this is important. For example, in 2000, we have reached the arrangement on reciprocal recognition and enforcement of judgments, and that's helped our developments substantially. So that's an example. And if I also had a chance to listen to the views of the Law Society today. It was our first meeting. The Law Society mentioned that for the mainland legal profession and the Hong Kong legal profession, there should be more exchanges and communication so we could better appreciate the features of each other's legal system. Now, I'm glad to help in that regard. I'll see how I could promote such exchanges and make sure that one country, two systems is fully implemented. So this is the suggestion we've got today, and we will carefully consider it and make the necessary arrangement. The third point I'd like to highlight is a criminal prosecution. Now, we've been doing training for new lawyers and barristers on criminal procedures and so on. It is hoped that we could help the new barristers and solicitors to take part in breathing out work. So we'll see what more we can do in this respect. And in my meeting with the Law Society just now, I also heard a suggestion, and we'll see how we could take that forward on for pro bono service. Now, there are retired lawyers or in-house solicitors who would like to provide pro bono service. So we'll see how we could make the arrangement. So there are more from the legal profession who could serve the public. Now, I haven't yet had a chance to meet with the Hong Kong Bar Association, but I'm meeting them on Wednesday. So for work related to barristers, I hope I'll be able to report in greater detail later. Apart from policy initiatives under the Department of Justice, we also provide legal advice to policy issues of other policy bureau. Now, of course, recently the most mentioned topic must be the co-location arrangement. The Secretary for Justice is one of the departments involved in actively promoting the local legislation exercise, or rather taking it forward. So for the Guangzhou, Zhuhai, Hong Kong, Shenzhen, Hong Kong Express rail link is hoped to be commissioned in the third quarter of this year. So we hope the legislation will be in place. So then the XRL will see its potential realized to the maximum, providing the greatest convenience to commuters. On the drafting exercise, the Department of Justice has been working closely with the relevant bureau and departments. And we also provided legal advice at the different levels of legal issues involving the bill. The bill will be tabled at the Council meeting this Wednesday, the 31st of January. It's hoped that before the summer recess of this session of the Council, the bill will be passed into law. And members will have a chance to consider further the bill in due course. Madam Chair, I hope the panel will continue to support the work of the Department of Justice. I and my colleagues will listen attentively to views of this Council, legal professionals, and the public so that we could do an even better job.
Madam Chair, just now I spoke on the policy initiatives of the Department of Justice. Here, I'd like to take the opportunity to say something about the unauthorized building works of myself and my companies. I'd like to say a few words on that. First of all, here I'd like to apologize again to the people of Hong Kong. I understand that Hong Kong people have high expectations of government officials. I understand that this incident has aroused a lot of concern and repercussions in society. I feel very sorry about this. Here, I solemnly again give my most sincere apology to the people of Hong Kong. I hope I will learn from the experience and then I can carry on with my work. Here, I also like to introduce again to you the latest development of this matter. On the 5th of January, I announced that I assumed office of the Secretary of Justice. In that morning, my family members received a letter from the Buildings Department knowing that at my Tuen Mun property there were suspected UBWs, or unauthorized building works. At that time, I immediately entrusted an authorized person to do inspection and assessment. And also, in the first instance, I reported to the Chief Executive. At the time, I wanted to give the latest situation as soon as possible to the people of Hong Kong, and therefore I did so once there was some development. I reiterate here that at that time, I bought the Tuen Mun property on an as-is basis. I did not know the owner, the previous owner, and I also bought my other properties on an as-is basis. After receiving the letter on the 5th of January, I entrusted an authorized person to inspect and assess my property in Tuen Mun. I also asked him or her to review my other properties and properties owned by my companies. The authorized person carried out inspection and assessment on my properties and my company's properties, and he agreed with the Buildings Department such assessments. And rectification plans have also been agreed to. Here I'd like to report to you the progress of the works. In my property in Tuen Mun, the rectification works have started. As for the industrial building unit in Fo Tan, the rectification has been completed. The old air conditioning support frame was replaced with a new one, but it was irregular and it was now taken down. As for the residential property in Sha Tin, the fire-resistant door is being worked on. A new one has been ordered. As for the property in Repulse Bay, the Buildings Department has confirmed that there should be 3 actionable structures that have to be worked on, and the contractor is poised to start work. And then there are 6 other minor actionable structures because they deviate in a minor way from the plan. Those will be rectified. Last but not least, Madam Chair, I hope I can apologize to the public again. This incident has aroused a lot of concern and queries. The way I handled the matter certainly can be improved. I hope I can make use of my professional knowledge and experience to serve the Hong Kong society and Hong Kong people. I hope I can use my professional knowledge and experience to defend the rule of law of Hong Kong and maintain judicial independence in Hong Kong. I hope I can work very hard to serve Hong Kong. I will do my best to serve Hong Kong. Thank you, Madam Chair. Thank you all. Thank you, Secretary. Since there are many people who would like to speak, as I said, I drew a line when I had 27 members on the list, but I saw 3 more come into the room and the time will allow all to ask questions. But then I will really draw a line there. I will now read out the order. Ted Hui, Claudia Mo, Michael Tin, Ronick Chan, Lo Wai Kwok, Fernando Zhang, Dennis Kwok, Ma Fong Kwok, Christopher Chung, Elizabeth Quat, Martin Liao, Tanya Chan, Kwang Chen Yu, Kwok Ka Ki, Jeremy Tam, Mok Lai Kwong, Alvin Young, Starry Lee, Kalena Wong, Chen Chi Chun, Felix Chung, Holden Chow, Yung Hoi Yan, James To, Cheng Chung Tai, and also Shu Ka Fai. I will give the floor to members as soon as possible. The first one is Mr. Ted Hui. Each one will have 3 minutes. Mr. Ted Hui, please. Thank you, Madam Chair. I'd like to ask the Secretary. When was it that Hong Kong people were no longer to talk about democratic self-determination? When was it that for participating in local elections, people's freedom of speech was limited? If today someone talks about democratic self-determination and they are debarred from standing, what if today someone talks about objecting to Article 23 legislation or vindicating June 4th? Where do you draw the line? Who decided on this? Was it the returning officer? Was it yourself? Or was Carrie Lam's government or Beijing? Secretary. Making a decision as to whether a nomination of a candidate is valid, that is the decision by the returning officer. It is not my decision. It is not the decision of the CE, Mrs. Carrie Lam. The decision is made by the returning officer. Procedurally, the returning officer gives consideration to relevant justifications and the legal basis. He has to work according to the basic law, electoral laws, and legislative council ordinances. Mr. Ted Hui, Secretary, did you yourself take part? Did you yourself give your legal advice with regard to the disqualification of a candidate's nomination this time around? Secretary, procedurally, if the returning officer has any questions about legal issues, he can ask questions. He will come to the Department of Justice, which will give legal advice. The legal advice will be about understanding the law. Is it your legal advice? It is the legal advice of the Department of Justice. What about yourself personally? Did you take part in giving that legal advice? The legal advice is the legal advice of the Department of Justice. Can you directly answer my question? Did you yourself take part in this? The legal advice of the Department of Justice is made by the department as a whole. Can you positively give this answer? Did you yourself take part, or did you personally participate in giving that legal advice? Okay, Mr. Tato is asking whether you yourself were involved. The Secretary for Justice would not have taken part in giving that advice. I think she has already answered you. Please do not act as a human tape recorder. Madam Chair, can I please talk about the procedure? The Secretary for Justice or Department of Justice will give the legal advice to the returning officer, who will make his own decision as to how to deal with the nomination. In the circumstance, he will consider the relevant facts and evidence. He will give weighting to the different factors and evidence and then make a decision. Therefore, the DOJ's work is just to give the legal advice to help the returning officer make a decision. But the decision must be made by the returning officer on the basis of law and facts. Next, Ms. Claudia Mo. Secretary for Justice is the head of the Department of Justice. Any view, any legal advice that is given must be the responsibility of yourself. Even if you did not involve personally in that matter, you have said something that you are convinced about. A returning officer cannot possibly have made that decision to disqualify a candidate independently. You came here at 4:45 and half an hour ago. Your government announced that Edward Yiu, his nomination was valid. It was perfect timing. But you said that there would be the disqualification of 2 people, but now there is only 1, so Hong Kong people, don't be so angry. I think you are controlling expectations. Hong Kong's laws, Hong Kong's rule of law have also been distorted by you. We talked about an authoritarian society. This is not just an authoritarian society. We are now ruled by men. My question is, if in a platform of a society you say self-determination is unconstitutional, so I'm asking you whether Demosisto is an unconstitutional organization. Secretary, I have not finished. Will the government take action to make such organizations illegal? If yes, when? If not, Why not? Secretary, the legal advice given by the Department of Justice, well, I have certain responsibility being the Secretary for Justice for that. As I said, our work is to give legal advice and tell the returning officer the legal basis for doing so. Chairman, that was not my question. I was making just a comment, but I'm talking about whether you are going to make Demosisto an illegal organization because you said they were unconstitutional. Secretary, the returning officer will look at the evidence before him. I'm not asking you about the decision of the returning officer, Secretary. You said that according to Hong Kong laws, if you want to take part in elections, promoting or advocating democratic self-determination is unconstitutional. So if that is an organization that is promoting this, will you outlaw that organization? Well, Secretary, let me talk about the procedure clearly. We are talking about whether nominations of a candidate are valid. That is going to be decided by the returning officer. But as to whether an organization is unconstitutional, it is not something the returning officer has to consider. I'm not asking about the considerations of the returning officer. I'm asking for the DOJ's consideration. Okay, other members can follow up on that. Mr. Michael Teen. Secretary, about your properties, you just gave an account, and I'd like to follow up by asking some questions. From the time of discovery of UBWs at your residence, and then it was found that the same situation could apply to your other investments. And then you gave an explanation, but then the buildings department revealed that there were more UBWs. You acted in a passive manner. We have heard your account today, and I think that there is no question about your integrity. But then, perceptually, I think you have failed. This is a huge public relations fiasco, and I have 3 questions for you, Secretary. Why did you choose that approach to talk about your properties? And will you be more sensitive when you do your work in your public office, and will be more active and proactive in answering our questions so that you will have a better image? And this is now an opportunity. Please now say clearly to the public what properties you directly or indirectly own and whether there are more UBWs that we still do not know about. And number 3, can you promise that no matter what UBWs there are, whether they are structural or non-structural, whether they have to be acted on immediately or not immediately in the eyes of the buildings department, that you will once and for all take them all down and demolish them immediately?
Secretary, thank you for the questions, member. Yes, the member was right to point out that in the way I handled this incident, there's room for improvement. I could do better. I've learned the lessons, and I have learned how I should have been more proactive and in responding to the public and members of this council in a more speedier manner. So having learned this from this experience, I hope I will be able to do a better job as the Secretary for Justice, and I will make sure the public well informed of my work. Now, there are no other properties under my name or under my companies other than those mentioned. For these properties, authorized persons have already carried out inspection and assessment. The authorized persons also conducted visits together with the buildings department. The buildings department's notices have been published in newspaper, so all the relevant work has been carried out, and there are no other properties involved. Now, whatever the buildings departments asked me to done, I have immediately and completely responded to those requests to carry out the rectification work. So whether the building department will act now or later, I am carrying out with full speed all rectification works. Ms. Ronick Chen. Thank you, Madam Chair. In the paper on criminal, there's mention of a criminal prosecution and law drafting. Now, I held public. I was a member of an ICAC committee. I found that very often the advice of Department of Justice has to be awaited, and that determines whether a case could be dealt with quickly or not. And then in the paper, it said that prosecution cases may be briefed out. That's paragraph 59 of the paper. Is it because you couldn't cope with all the cases, or some cases have been in the queue for too long? So how do you brief out such cases? Is there a certain briefing out ratio? So there is a cap on the ratio. I don't know if that's the case. So can I ask the SJ to explain that to us? The other question is on law drafting. Now, when we scrutinize bills, I often saw members expressing views about the Chinese provisions, and on if there are technical issues involved, usually there would be many amendments proposed. Now, in the paper again, paragraph 65, you refer to promoting the professional abilities of your staff. And you will also try to promote continuous professional development. Would you be more specific on the different fields, say for healthcare and whatever? So when it comes to law drafting, the work will be done of a high quality. Secretary for Justice, I have to, perhaps I need my colleagues to help me find out whether there's a cap on the ratio of briefing out cases, but it really depends on the nature of the case. If a case is particularly complex, the Department of Justice may have already formed the legal advice, but maybe we need to brief out a barrister or senior counsel from outside the department to help us look at the case again. And then there are also cases of a more sensitive nature, whether they be politically sensitive cases or cases of great interest to the community. So apart from relying on internal advice from within the department, we will try to seek outside advice. Now, would we also brief our cases when we couldn't cope with our workload? I believe that is not the case. Usually when we seek advice from outside counsel, it's because there is a need to do so. Ratio. We do not have, we have not set a ratio as such. It's not like each year we would limit it to so many number of cases. Rather, we will look at the nature of the cases. Could you provide any information in writing later? Thank you. Next, Dr. Lo Wai Kwok. Thank you, Madam Chair. For the development of the Macau, the Bay Area, the Belt and Road Initiative, they could bring about new opportunities to professional services in Hong Kong, sectors in Hong Kong. Now, the Secretary mentioned legal services, especially legal and dispute resolution services. I agree Hong Kong has an edge for arbitration and mediation in particular. I hope Hong Kong will benefit from the opportunities brought about by the Belt and Road Initiative, because there are many Belt and Road countries covered in the initiative. But how can we help young people to seize upon such opportunities? Now, I'm not worried about the bigger professional firms or the more experienced professionals. What about young professionals? How can we help them? As another point is about your personal issue, arbitration. Now, we're told that there are 6 arbitration cases for which you have applied to the Chief Executive to wrap up. Of course, you're not taking up new cases. Can you explain why you couldn't ask someone else to wrap up those cases? Why must you do so yourself? Secretary. Thank you. For the Bay Area Development and the Belt and Road Initiative, yes, they bring about some unprecedented opportunities for the legal sector and other professional sectors. Now, what the Department of Justice is doing is that we're trying to promote Hong Kong laws as the applicable laws. And they can also use Hong Kong as the place of arbitration. And if necessary, they should also take cases to Hong Kong courts. And Hong Kong could also be a mediation center. Now, how do we promote that? As I said earlier in my opening remarks, we need more young people to join this sector. So maybe we could have some pilot schemes for locally trained lawyers so they could take part in the smaller cases, and eventually they were able to participate in the bigger cases. So they could therefore benefit from the opportunities presented by the Bay Area Development and Belt and Road Initiative. So we could do something here. And then on promotion, can I finish, please, Madam Chair? Yes, please do. Thank you. Now we also we need to present Hong Kong's unique advantage because we've already established ties with the mainland. So for lawyers from these countries and for government officials from these countries, they have to learn more about Hong Kong. So we need to visit them, and at the same time, through training arrangement, local legal professionals could have exchanges with the professionals and government officials of these other places, and then these places will come to learn more about our advantage. Can I please also go on to something else? Please try to wrap up in a minute or two. Now, for the 6 cases, they are different than other cases. I have already resigned as the arbitrator for many other cases. But for these 6 cases, they are about to be concluded. All the submissions have been made, and if I now quit as the arbitrator, there is a chance that more time and more money will need to be spent on the cases, and there's a chance that the hearing has to be done all over again, and it may not be fair because already one party has heard the evidence of the others and they could adjust their own evidence, so it may not be a fair hearing. That's from the point of view of the parties involved, but I think it's even more important to consider this from the point of view of Hong Kong. As I kept stressing, we are actively promoting Hong Kong as a leading arbitration and dispute resolution center. If just because I'm a Secretary for Justice, and then I could just drop these 6 cases, I don't think that would bode well for the reputation of Hong Kong as an international arbitration center. So that's why the Chief Executive has granted me permission to finish these 6 cases where circumstances allow. And this is not going to take up too much time. Definitely, I'm going to give priority to the work of the Secretary of Justice, and then I will spend time on these cases. The parties involved are well aware of that. Thank you. Thank you. Well, I would like the Secretary to give answers, but if there's a need, I can also give up my time so the Secretary could give further explanations. Dr. Fernando Zhang, it doesn't matter how many apologies you offer, you're still Secretary of Justice who breaches the law knowingly. You are an engineer. Your husband is an engineer. Your husband was actually the former president of the Hong Kong Institute of Engineers. And you published a textbook on unauthorized building works, Secretary. You've also been acting for clients in UBW cases in court. And you were also in the appeal panel on building works, the appeal tribunal panel. So you should, of all people, should have been the one to have noticed UBWs. But on the very first day of you assuming the post to defend the rule of law in Hong Kong, you breached the law knowingly. And we couldn't even count how many properties, how many UBWs were involved, straddling over a long period of time. And then you said it was negligence, you were not vigilant enough. It simply was not enough to explain that away, to say that it's just negligence. So on the first day you're supposed to defend our rule of law, you have lost completely your integrity. The impression of the public on you is that you're someone who breached the law knowingly. In fact, you probably even exploit your legal knowledge to maximize your own benefits. So as a person of Hong Kong, would you have trusted a Secretary of Justice like that? Secretary, thank you, member, for the question. As the owner of the property, where there are unauthorized building works and I did not do immediate inspection and rectification, yes, I have to show the responsibility for that. Now, when I accepted the appointment to become the Secretary of Justice, I had thought it through very carefully. I hoped to have relieve myself of all my other private private practice duties and so on, so I could serve Hong Kong with my legal knowledge and experience. So I put first and foremost the work of the Secretary for Justice, so that we could continue to defend the rule of law in Hong Kong and judicial independence as well, and also we could do even better in terms of awareness of the rule of law. So I hope the public will give me the opportunity to prove to you that as the Secretary of Justice, I will make sure I do a proper job. Mr. Dennis Kwok. Now, before you assumed your post, the SL government should have conducted vetting on you. Did integrity checking? Did they ever ask you whether there were UBWs? Well, I don't think we should comment on integrity checking here. No, my question is whether the SL government asked you if you had any UBWs in the integrity checking process. That's a straightforward question. Well, there's need to keep the extended checking process confidential. No, sorry, Secretary, you cannot say this over and over again and try to evade the question. Mine is a straightforward question. During the integrity checking process, did you ever reveal to the SL government that you had UBWs?
Secretary, during the procedure of the integrity checking, well, I think everything had to be kept confidential. So whether it was asked whether what I said amounted to anything, I could not say. Sorry, Secretary, so you have no remorse even when you come here and you are not trying to explain the entire matter, because the biggest query is, as Dr. Fernando Zhang was saying, why is it that you did not know that there were UBWs at your home and in other properties? When you knew, why did you not reveal that during the integrity checking process? Secretary, Madam Chair, I already said that the integrity checking process and everything involved in it cannot be disclosed here. Then how do you think Hong Kong people can trust you that you can be the Secretary for Justice? It's not just the legal sector. Hong Kong people have high expectations of this post. I'm asking you this very simple question. Did you disclose your UBWs at integrity checking, you would not say you are hiding behind the so-called confidentiality clause. Sorry, Secretary, that won't do. I am asking you again, did you disclose to the SAR government during integrity checking that you had UBWs, yes or no? Let me try to reply to the question by the member like this. Integrity checking has to be kept confidential. I believe Mr. Dennis Kwok knows very well as a lawyer or as a counselor, if there are things that have to be kept confidential, they should be kept confidential. Why has this to be kept confidential? Now someone has happened, and I'm asking you whether you declared it to the SARG at the time. This is going to be a loophole of the entire integrity checking process. Did you disclose it? Did you declare it? Why do you have to keep it confidential? If you said no, then you should say no here, or you can say you just forgot about it. But now you are hiding behind this confidentiality clause. You are acting in a most irresponsible manner, and you are not answering our queries. Secretary, Madam Chair, I am of the view that I already answered the question. This is a well-established system within the government. This system has to be kept confidential. As a government official, I should keep it confidential. Mr. Marvin Kwok. Thank you, Madam Chair. I'd like to talk about the national anthem law. On the 1st of October 2017, the national anthem law of the PRC was promulgated, and on the 3rd of November 2017, NPCSC has ordered that this be listed in Annex 3 of the Basic Law of the Hong Kong SAR. And according to the order, Hong Kong has to make its own legislation. I'd like to ask a question. The Macau SAR has already said that the drafting of the relevant law will be completed in January. I'd like to ask the DOJ, what is the progress of the drafting of the national anthem law in Hong Kong? Has the DOJ finished the drafting of the law? When will it be submitted to LegCo for scrutiny? Next, about the national flag law, those were promulgated before the return of sovereignty of Hong Kong, and the blue bills were ready and they were submitted to the provisional legislature for scrutiny, and they were passed 2 weeks before the reunification. So, Secretary, would you take reference from those two pieces of legislation and make use of the same legal principles in order to complete this part of your work? Secretary. Thank you, Chair. Thank you, Member. The Constitutional and Mainland Affairs Bureau has already started to do preparatory work for entrenching the national anthem law in Hong Kong. The DOJ will provide legal advice in the process, and we will provide support for drafting the piece of legislation. When we make local legislation on the national anthem law, our principle is to maintain the original purpose and principle of the national anthem law, to maintain the integrity of the national anthem, and also that nationals should respect the national anthem. But we would also have to have regard for the common law system and its protection in Hong Kong. We therefore hope that within this legislative session, we'll be able to submit the draft law for scrutiny. For now, we do not have a detailed timetable for doing so. Last but not least, whether we can take reference from the national emblem law and national flag law, I'm sure we can certainly consider taking reference from that. I think the CMAB has also heard you. I'd like to follow up. With regard to the penalties in this law, will you take reference from the penalties in those two laws? Secretary, we will take reference to similar provisions when we draft the law, but as to what will actually be done, we will have to wait for the preparatory work to be finished by the CMAB, and also after we have drafted the law. Then we can report to LegCo again. Mr. Christopher Chung. Thank you, Madam Chair. With regard to the UBWs, the Secretary has already given accounts to the public many times, and she has also advanced sincere apologies. She has also ordered for the UBWs to be rectified. I hope the Secretary will be allowed to carry on with her work. I'd like to ask the Secretary, the administration has already done a lot in helping to resolve disputes in the financial area. I understand that before joining the administration, you have been heavily involved in promoting mediation. I'd like to ask you how you can further promote the resolution of financial disputes and how the successful experience in resolving financial disputes be expanded to other sectors and strata in society. There will be many commercial opportunities and investment opportunities in the Bay Area and also under the Belt and Road Initiative. And there are bound to be disputes. But then we are acting under two systems. How can you do mediation so that investors can benefit from the saving of time? Secretary, thank you. Sorry, Chair. Thank you for the question. The Financial Dispute Resolution Center is doing some very important work because when small investors are in disputes with large financial institutions, this center can certainly help a lot. The member mentioned two systems. In fact, this is exactly the advantage of mediation, because when you do mediation, you don't have to assign responsibility under what laws, but then you will try to achieve a win-win situation. I therefore hope that this Financial Dispute Resolution Center can further promote and share their experience. Because I remember almost 80% of cases have been successfully mediated. And part of their work is to promote mediation. Therefore, I think their experience can be promoted to other areas. In Hong Kong now, whether we work with the mainland or other places, if we cooperate on the financial side, we can also learn from the experience and allow the public and investors to make use of the mediation service. Next, Ms. Elizabeth Quat. Thank you, Madam Chair. Secretary, in your paper today, you were silent on the follow-up work on the illegal Occupy Central campaign. 3.5 years have passed since September 2014. Many of the participants or organizers have not been prosecuted, and many people in society are questioning whether indeed everybody is equal before the law. There are students, academics, and even media tycoons. Is it that they cannot be prosecuted? Just now you talked about your duties and your work, and that is to maintain the rule of law. Can you explain to the public why is it that until now there are so many people who have not been prosecuted? How will you do the follow-up work? Secretary. Thank you, Madam Chair. Thank you, Member. In deciding whether we would take out prosecution, the DOJ will have regard to the law and the available evidence and will act according to the prosecution code. Sometimes decisions are easy, but sometimes decisions can be difficult. I understand that we need time to gather evidence and analyze the evidence gathered. I agree with the member that we should act as soon as possible how this should be done. After assuming office, I shall make a decision as soon as possible as well, certainly upon the basis of the law, evidence, and the prosecution code. There will be no political factor because we act according to Article 63 of the Basic Law, that we will be free from any interference. I hope there will be an opportunity for me to make the decision so everybody knows where we are. Here, I'd like to emphasize a point. There are absolutely no people who have any privilege, whether they are tycoons, whether they are an average person in society, whether they are the media, government officials, or members of the council. They are going to be dealt with when we objectively analyze the law. Ms. Quat, Chairman, as I said, 3.5 years have passed and some people have been prosecuted, but those who were promoting the illegal Occupy Central campaign have not been prosecuted. Secretary, when you assumed office, did you seek an understanding into why there has been a delay of over 3 years? What were the problems so that these people, these organizers, were not prosecuted? Why was this delay? Secretary, here I cannot tell you why there is this delay, because before we make decisions, our prosecution work has to be kept confidential. But I'm aware of the timing factor because different people have mentioned that point to me. I am aware of this point and I will take a look as soon as possible. Mr. Martin Liao. Madam Chair, in order to satisfy the needs of I&T and the new economy, the stock exchange is going to introduce the weighted voting right structure so that in the GEM board, we will be able to attract locally and foreign incorporated companies. The U.S. has accepted the weighted voting right structure because in that place they have the class action system. As you know, given class action, there are many complex issues. Whether or not Hong Kong will adopt such a system, we have to look at the protection to investors and also maintaining Hong Kong's business environment. We have to strike a balance between those two, and we also have to guard against abuse. I'd like to ask the Secretary, when you consider the or study into class action, what is your progress? Will you be able to announce further progress this year? Secretary, thank you for the question. A few years ago, there was a report on class action. We also set up a working party to follow up. The working group held many meetings to look at relevant issues. But I think members will understand that when we talk about relevant issues, very often when a certain point is discussed, you will have to review what has been agreed upon because there will be interconnection among the points considered. Therefore, with regard to progress on class actions, it is not as fast as you think, but we are working very hard on it. I hope that at a later stage within the year, we can at least be able to give an introduction to the issues we have encountered so that you know what problems have stood in the way. I agree with the member that we have to consider different factors, whether it is about the economy or whether it is for the people or it is about the judicial system in Hong Kong. We have to consider all these very carefully. Any supplementary? When you do the study, did you consider the views of the Chambers of Commerce? Secretary, we understand that certain Chambers of Commerce have views. If necessary, we would be very happy to listen to the views again. Yes. My colleague just reminded me that at the working group, we also have representatives of the business sector. There is this communication channel, and we'll continue to listen to the views of Chambers of Commerce and the business sector.
Ms. Tanya Chen, thank you, Madam Chair. Now, I'm not a member of this panel. I would like to thank the Chairman for giving me the opportunity to ask questions. Last Wednesday, the Secretary for Justice did not accept, said he should not accept she is a person without integrity. So, Secretary, can you accept that if someone lies to you? Sorry, I didn't catch it. Yes, can you ask your question again? Would you accept if someone lies to you? So the question is, would you accept if someone lies to you? Is there anything else? Sorry, Madam Chair. I don't quite follow the question. No, I don't know if you saw the photo I show you through the steward. It's actually a building plan of Villa de Mer. That's your residence. I showed that plan at the council meeting, but then Carrie Lam said she couldn't answer on your behalf. You know, there are 3 steps with buying a property. When you sign a sales and purchase agreement, there's your signature in it, and it showed here you inspected the property. So in your mortgage deed and in your assignment deed, in both documents, it's stated clearly there is not a basement, and it's also shown as such in the plan. So for these 2 deeds and even for the sale and purchase agreement, how come you signed all 3 documents? It's your own signature on all 3 documents. Secretary, thank you for the question. I would like to respond this way, Madam Chair. I did say that I am the owner of this property, and there are UBWs. Sorry, I have to disrupt you. Or interrupt you, rather. Can I give you one more point, a basis to consider? Now, you said you are not an authorized person, so you do not know what is UBW. And all 3 documents here are legal documents unless you deny you are a legal professional. Secretary, please. Well, I said earlier, yes, I did sign these documents when I bought the property, and I am the owner of this property. So, did you lie deliberately when you signed the documents? Did you lie deliberately when you signed the documents? Please let the Secretary continue. Continue, please, Secretary. Yes, I have to shoulder the referee responsibility for UBWs on the property. Did you lie when you signed the document, Secretary? So I have to shoulder the responsibility. Did you lie when you signed the documents? Ms. Chen, please allow the Secretary to finish. Please finish. As a legal professional, did you lie when you signed the contract? Secretary, I'll give you ample time to reply. Please give time to the Secretary to reply. Now, I bought the property as is. Looking back, yes, I did not review in time. I did not handle it in time. No, you reviewed it. You inspected it. You're still lying. Well, Ms. Tanya Chan, I think the Secretary has answered your question. Next, Mr. Roy Kwong. Thank you, Madam Chair. Secretary. You know, every day something new comes out, and one is worse than the last. Now, as soon as you assume polls, the media exposed that there were UBWs on your property, and then every time something more is revealed, is worse. And you said just now you apologize, but how sincere is your apology? Your latest popularity rating is 38.9. You are last among the 3 secretaries of department. So you want us to give you a chance, but who would give a chance to Agnes Chow? Who would give a chance to the candidate you disqualified? Now, you are not setting the right example. You are beleaguered by scandals. Would you consider resigning? So at least then you could save the much-cherished spirit of rule of law here. Secretary. I considered the appointment very carefully before I accepted it. And I have set aside all my whole private practice except for the 6 cases mentioned. So I have every determination to serve Hong Kong. Yes, these cases have sparked much concerns in the community and repercussions as well. For that, I sincerely apologize to the public and to members. So you have determination to serve Hong Kong. What about the candidates disqualified? Don't they have the determination to serve Hong Kong? Are they not sincere? And you're disqualifying candidates as political vetting, and then you blame it on your junior staff, a returning officer. But you're the Secretary for Justice. Why don't you assume responsibility? Now, you asked, but you dare not answer. Can I ask you again? Is it your decision to disqualify the candidate? Answer me. Were you involved in that decision? Please allow the Secretary to answer the question. On deciding whether a nomination is valid or not, don't try to blame it on your junior staff. You are the senior official. So to help me ask, Madam Chair, were you involved in the decision? Secretary, I'm sure she knows full well what your question. Please let her answer. Thank you, Madam Chair. Thank you, member. In deciding whether a nomination is valid or not, it is a matter for the returning officer. It's not my decision. And when the returning officer considers a case, he will have regard to the relevant legal advice. So you were not a part of this disqualification decision? Please let the Secretary finish. Now, the returning officer would consider the legal advice given by the Department of Justice. The returning officer also has to consider the evidence before him or her. And then a balance has to be struck. And then the evidence has to be interpreted in accordance with the law and before a decision is made. So the decision is made by the returning officer. Actually, the early part of her reply already answered to your question. No, she didn't answer one question. Would you resign? Would you bow out? Secretary? Yes, please, answering in. Thank you, Madam Chair. When I decided to accept this appointment as the Secretary for Justice, it was after very careful consideration. I have determination to perform my duties as Secretary for Justice properly. Now, this case, this incident, has sparked much public concern. I am deeply apologetic about that. I hope members of the public and this council would show some understanding that before I handle this case, I caused so much concerns to you. Now, I have the same conviction as I was in other public offices. I wanted to use my legal knowledge and experience to serve Hong Kong impartially and fairly. So you just would not resign, right? Mr. Roy Kwong, I've allowed you a bit more time. She has answered your question, or maybe not directly, but she has answered your question. Dr. K.K. Kwok. Thank you, Madam Chair. I've never seen someone so shameless, someone with so much knowledge, so educated. She lives in this house with a huge basement. I think it's common sense that this is UBW. But you lived in that property for 9 years and you kept lying to say that you knew nothing about it. So you have no more integrity left and you are being evasive and there's no point asking you any more questions. Now you asked on many occasions for forgiveness. Agnes Chow was disqualified in the by-election. She's a young person. Nathan Law of the Hong Kong Demosisto only mispronounced one character for People's Republic of China, but he was not forgiven. And now you could go against Article 26 and 27 of Basic Law. You're denying them of their rights to run an election. You're denying them of their rights for freedom of speech, freedom of information, and so on. And you're also denying them of the rights under the International Covenant for Political and rights, to which Hong Kong is a party, signatory party. Now, we all know that you are covering one lie with another lie, but you don't feel shame at all, and then you ask for forgiveness from people of Hong Kong, and these young people, they only said one character wrong, and you try to, drive them all and deny them of all opportunities. Don't you feel shame in front of these young people? And then in deciding against Agnes Chow's nomination, the returning officer said that legal advice was considered. Now, the articles of the Hong Kong Demosisto mentioned self-determination that's against the principle of one country, two systems. What exactly is against the principle of one country, two systems? Why is it not the case that this particular decision of the returning officer is against the basic law, the ICCPR, and so on? Secretary, I have great respect for freedom of speech, freedom to stand for election and the freedom to vote of the people of Hong Kong. Now, I understand when the returning officer makes the decision is on the basis of the law. Madam Chair, I'm running out of time. I asked my question. Don't pretend you don't follow it. Now, the returning officer has considered legal advice, and that came from you. So you've got nothing to do with this? True. It's the Department of Justice which rendered legal advice to the returning officer. The legal advice must be a result of assessment of the facts. So that's why I'm asking you, which in this article is against one country, two systems. So it's on legal advice, Secretary. Our legal advice to the returning officer is on a confidential basis. That's important. Well, there are many lawyers here. When lawyers render advice, legal advice is subject to legal privilege protection. So it's not for us to disclose the advice. My apology. While we're paying her millions of dollars to give legal advice, and you say legal advice is confidential, you have to answer to the public. Well, the secretary said on several occasions that she was involved in the legal advice. No, what is the legal advice? I want to say that there are 15 members still waiting to ask questions. We hope that latest by 6:35 we are able to deal with your motion. So I'll be very strict with the 3 minutes speaking time limit. If you want the secretary to have to be able to answer a question, please be brief with your questions, or you could share out the questions among your colleagues. Mr. Jeremy Tam. Thank you, Madam Chair. At the Fulton Industrial Building, the secretary said there's just one UBW. That's the air conditioner frame. Can I confirm if that's the fact? Secretary. For the Fulton Industrial Building unit, the air conditioner frame has been removed. Are there other UBWs, or were there other UBWs? Any others, Secretary? The Buildings Department mentioned an external wall. My authorized person followed up with the Buildings Department, and there's no need to remove it. So that's why I only refer to the removal of the air conditioner frame. As for no, it's a petition wall rather. It's a petition wall, and there's no need to remove it. Because there were reports before, apart from the air conditioner frame, there wasn't a proper fire-resistant door, and there was an added partition wall. What about the fire-resistant door? Well, that's why I would like to make that clear here. The fire-resistant door is about my other property in Sha Tin. Okay, fine, no problem. Let's talk about your partition wall first.
Did the fire services department come to look at the sprinkler system about the partition wall? My authorized person and the buildings department have done inspection. They have agreed on what should be done. The assessment has been done, and I will act as soon as possible to cooperate with the buildings department. No, I'm asking you about the sprinklers. Are the sprinklers also following the regulations, because you have got a partition wall there, and I'm asking you about the sprinklers. Are they also breaking the law? Secretary, Well, I believe if there has to be ratification done, my authorized person and no, I'm asking you whether something has to be done. If something has to be done, it means that it is illegal. So has something to be done? Chairman, can I please explain? Yes, I will be brief, but please let me finish the sentence. Sorry, member. My authorized person and the buildings department have done an inspection. Whatever has to be done will be done and will be done quick. So we are cooperating. Well, I have to remind you, you are dragging your feet. I'm asking you whether the sprinklers have been moved. If they have been moved, there will be a potential fire hazard. You are not caring about the safety of our firefighters, because if the sprinklers have been moved, because if you have changed the structure or the partitioning of the unit, the sprinklers might have been moved and then it will be unsafe for the firefighters. Secretary, no one told me that the sprinklers had to be worked on. I have not heard anything about it, and I must emphasize that the partition wall was originally there. Mr. Kenneth Leung, the para 10 of the notice to Agnes Chow from the returning officer is such that the returning officer has considered the interpretation of the Basic Law by the NPCSC, and that is Article 104 of the Basic Law. That is one reason for considering the nomination invalid. Now, I don't understand why the interpretation, which is about the form and content of oath-taking, why would that be related to the qualification of a candidate? This is a simple legal question. Please answer me directly. Secretary, thank you for the question. Article 104 of the Basic Law, you will see that the NPCSC has given an interpretation. And then in para 1, it says that Article 104 of the Basic Law stipulates that there must be the swearing to uphold the basic law of the Hong Kong SAR of the PRC and swear allegiance to the Hong Kong SAR of the People's Republic of China. This is the statutory content that must be included in the oath, and this is also the statutory requirement and condition for anyone trying to assume the office, whether it is a candidate or someone who is going to take up the office. So you must swear to uphold the basic law and also swear allegiance to the Hong Kong SAR. But then there are cases which are still being handled by the court. But then when you talk about oath-taking, well, this will happen when a candidate is elected. Why is it that before someone is a candidate, before oath-taking takes place, how can you decide that the nomination is invalid because oath-taking will be on an appointed day after the election? Why is it that you can act according to Article 104 of the Basic Law? Because the returning officer has cited that as an important reason for considering the nomination invalid. Secretary, what was your legal view? Article 104 states that when assuming office, there is this statutory requirement and condition. In the judgment or ruling of Justice Au, he has talked about the theme and policy of the Basic Law, that we should uphold the Basic Law. And to consider whether the candidate will be making the oath effectively, he has to be sincere and true. Now, how can you tell whether someone is sincere and true in taking the oath? Do you have to use a lie detector? Secretary, I was referring to different law provisions. Because of the constraint of time, I can only give a brief reply. Can you ask the Secretary to give us a written reply that is on Article 104? Well, our panel can follow up on that issue. Mr. Yik Chi Ming, or Frankie Yik. Thank you, Chair. We have all heard that the central authorities would support Hong Kong to develop into an international shipping center. And one of the issues is about maritime arbitration. I represent the maritime sector, and we are very concerned about progress in this aspect. We are at the southern gate of China, and we have always had a role to play in terms of arbitration. Hong Kong is also a signatory to the New York Convention. Therefore, Hong Kong arbitration results will be effective in all the 105 signatories to that convention. Secretary, I'd like to ask you, in promoting Hong Kong as a legal and dispute resolution center, what is the progress? Are you exploring the issue and their interests with local and international legal bodies? What is their reaction? Are they interested? Secretary, with regard to maritime arbitration, Hong Kong has achieved good progress. The member mentioned the New York Convention. Hong Kong arbitration awards have been followed in the majority of cases. As for the maritime aspect, Hong Kong enjoys a very good position, and very often there are maritime arbitration cases. So both have worked for the advantage of Hong Kong. I hope members are aware that if we make use of our maritime advantage, and if we will continue to develop our arbitration work, and I'm sure our arbitration experience will further accumulate. Mr. Frankie Yik, I was asking the Secretary whether she has started to contact local or international legal bodies and how they react, or are they interested in helping Hong Kong develop into a maritime arbitration center? Well, yes. All along, the administration and private bodies are in contact with international marine experts. Say the Marine Arbitration Center in London, we have been consulting these bodies. We are maintaining communication with them, and locally there are many organizations that will support Hong Kong's maritime arbitration developments. Therefore, all along, we have been in contact with local and international bodies. Next, Mr. Wu Chi-wai. Thank you, Chair. I'm looking at this notice of decision to Agnes Chow. In fact, the first 9 paragraphs are actually the same as what Mr. Nathan Law received back in 2016, and Mr. Nathan Law was allowed to stand as a candidate. But then para 10 is the gist of that notice, because after interpretation of the Article 104 of the Basic Law, we don't only take the oath towards the Hong Kong SAR, but now it has become the PRC and the Hong Kong SAR. So we are going to take the oath to swear allegiance to 2 constitutions. In 2016, democratic self-determination was not a ground for disqualification, but after interpretation, democratic self-determination has become a ground for disqualification. It is because the central authorities or the Chinese Communist Party don't think that this is a statutory condition for taking part in the election. Today, according to the Chinese constitution, you disqualify democratic self-determination, and also putting an end to one-party rule is also against the Constitution of China, isn't it, Secretary? Secretary, with regard to the returning officer's decision, we gave her the legal advice, but the decision is made by her. With regard to Hong Kong independence being a choice or an option, the CE has mentioned. No, I'm asking the Secretary, putting an end to one-party rule, when will you act according to that bottom line? Secretary, when we consider whether a candidate complies with the statutory conditions, we do not have any political considerations. We have to see whether she or he signs in a sincere and true manner to uphold the basic law and swear allegiance to the Hong Kong SAR. When someone signs the confirmation form, yet you try to guess her intent, it seems you are examining her thoughts to see whether she is true and sincere. What else can you do to allow Hong Kong societies to still have the due process? Because in Hong Kong, when we go by due process, we don't guess people's intentions. Are you adding a new element to this, Secretary? When did you add that new element? That's the question. Sorry, I don't really understand the question. I am asking you, legally speaking, when have you started to guess people's intentions? Are you going to answer the question? He is asking, since when you try to look into people's thoughts? When we handled the case of Chan Ho Tin, the DOJ made use of the proposition of truly and genuinely. When someone took the oath, that is a basic condition, plus Article 104 interpretation and the first paragraph that I read out, it is a statutory requirement and condition. Therefore, from a legal point of view, we need to know whether someone is true and genuine. Next, Mr. Charles Smock. Secretary, when you last came to the Council, you said that you would not accept that you are a person of no integrity. I like to say that Hong Kong people, particularly the young and myself, do envy you that you have the opportunity to say such a thing. Maybe Angus Chow would like to say also that I don't accept your accusations against me, but then the so-called returning officer, who is a civil servant acting in representation of someone, has already given her the death sentence in a political sense. I hope you will understand why Hong Kong people are so angry. I have been listening to your replies, Secretary. I think you are well prepared. You are also more patient. And before the meeting, half an hour before that, a candidate's nomination has been ruled valid. But unfortunately, on other issues of youth unauthorized building works and disqualification and regarding facts and evidence about these, we haven't heard any about that. I believe the public would like you to be even better prepared in those aspects so that we will have a better understanding of these two queries in our hearts. Mr. Dennis Kwok asked about the integrity checking. In fact, this was also what I asked last week orally. You said that it has to be kept confidential, but I hope you understand that if you don't give the facts, then we will suspect that the system is problematic. We will suspect that your boss, the chief executive, may know something, but she doesn't say so. We will also suspect that the civil servant who handled the integrity checking, he might be negligent of duty. In fact, you will just give the facts so we do not have to doubt the system and we do not have to have doubts about some other people, which may be unfair. So why don't you just give a direct answer? And in the law or in terms of government regulations, does it say that you also have to keep confidential your own statements and not other people say? Maybe give some time for the Secretary to answer, please. As I said, the integrity checking system has to be kept confidential. I also have to respect my communication with the CE. I will not divulge anything about that either. I am worried that the CE respects you, so she doesn't say anything about you. But the thing is, if you come clean here, people will not have more doubts. But if you don't, the pro-establishment camp members will also have to understand that on Wednesday we are going to move a motion on Article 73, bracket 5. You have to support it before you can get the information. Mr. Horace Chung, Madam Chair, the Secretary for Justice has an important post and important duties. We all understand that. But after assuming office, our attention has been focused on your properties. But we haven't had any opportunity to understand your competency or otherwise, and also your views on important legal issues. Madam Secretary, the Legislative Council has to deal with the co-location enactment very soon. You understand that there are controversies in society about this, and pro-democracy members have refused to accept it, and the Bar Association has a different understanding of the issue. You are a very experienced barrister, and you also have a high status in international arbitration. I'd like to ask for your view about the local enactment of legislation for co-location. This is a very important piece of our work. Secretary, thank you. Thank you, Chair. The bill has been gazetted last Friday, and on Wednesday, that is the day after tomorrow, it will be read the first time. This is on the basis of the cooperation arrangement, and the provisions of the local law have been written on that basis. When the provisions were drafted, we communicated with the Transport and Housing Bureau and also Security Bureau to reflect what they have to deal with, and these are in the provisions. I believe at the Bills Committee, I'm sure we can scrutinize the provisions in detail, and then we will give detailed explanations. No follow-up. Mr. Alvin Young. Madam Chair.
Now, in 2008, the Secretary signed the relevant legal documents on his Tuen Mun property, the bank mortgage deed and other documents. Now, she honestly believed what she signed was true and accurate, right? Secretary, yes, I did sign these documents. And, well, for documents I've signed, I have to admit that I've signed them in this way. Those documents did not include the basement in your Tuen Mun property. So at the time when you signed the documents, you truly believed that was the case, right? Secretary, when I signed the documents, I did not notice specifically what was written there. But yes, of course, objectively, there's not the term basement in those documents. So objectively, I could appreciate that Mr. Young or members of the public may have certain views. No, there's no need to talk about being objective or subjective. The facts are the facts, as the Chief Executive said. So the Secretary has signed a relevant legal document that's not in line with the facts. And now the Secretary and the Chief Executive asked that we give the Secretary a chance. We should be tolerant. So that's a fact too. I don't need you to answer the question. Now I want to ask about disqualification. Now, when you gave legal advice to this returning officer of the Hong Kong Island, did you try to give others an opportunity? Were you being tolerant? Secretary, when the Department of Justice rendered legal advice to the returning officer is on the basis of legal principles. The returning officer then made a final decision based on the relevant evidence. How many sets of legal principles are there now in Hong Kong? The Secretary believed that when she signed a legal document wrong, then we could accommodate her, we could give her another opportunity. But now there are young people who want to run an election, you wouldn't give them any opportunity. So how many sets of legal principles and legal basis do you have, Secretary? Now, is the returning officer who's the person to decide whether a nomination is valid or not? We only render legal advice and help the return officer comes to a conclusion on the basis of the information he has at hand. Under what circumstances would you make public legal advice rendered? Under what circumstances, Secretary? Well, Mr. Young is a lawyer himself. You know that we cannot make public legal advice. Okay, the Secretary has answered the question. Next, Dr. Helena Wong. I don't think there's anyone in Hong Kong who would believe that the disqualification of a candidate is purely the decision of a returning officer. And we know the returning officer has sought legal advice from the Secretary. So what legal advice did you give? And you said that's confidential. There's no way the public can find out. So is it your decision to disqualify Agnes Chow? And was it also your legal decision to let Edward Yeo off the hook? You said nothing, and now you said this is the decision of the returning officer. So can I ask you this, Secretary? If the returning officer did not take heed of your legal advice and went the other way, what would you have done? Would you have disqualified the returning officer? Secretary. Now, on deciding whether the nomination is valid or not, for any candidate, it is a decision for the returning officer. The Department of Justice renders legal advice, and it's not just a simple legal advice, but it's rather based on the relevant facts. It's not for me to decide one way or the other. So whatever is the outcome, as the Secretary for Justice, there's nothing I can do about it, because the decision is the decision of the returning officer. So I've said this many times. I hope members would appreciate that. So the set of circumstances mentioned by the member does not actually exist. Can I ask the Secretary to clarify this? Does the returning officer have the power to go against your legal advice? The returning officer has his or her duties and obligations to make the right decision given the legal circumstances. When making a decision, he or she does not just refer to the law, he must also assess the relevant facts and balance the evidence before coming to a final decision. Now we are the party that renders the legal advice, but the ultimate decision is for the returning officer, and it is not a purely legal decision. So this is not purely a legal decision. That means it's also a political decision. And if this political decision is against your legal advice, would you pursue the returning officer, or would the SL government pursue the returning officer for responsibilities? No time to answer that. Next, Mr. Ray Chen. Madam Chair, Ms. Teresa Zhang is a senior counsel. She is a civil engineer. She was also the chair of the building appeal tribunal panel building. So she's got plenty of experience, and she's definitely the expert of on UBWs, and everyone now call her UBW Teresa. So I have a question about unauthorized works, not on properties, but on the basic law. Article 104 of the basic law. Originally, it's just principal officials and members of the Legislative Council are governed under this provision in the way they take the oath. But now there are other elements added to it. Now, this is supposed to be an article to govern the oath-taking process after a member has won in an election. But now you have imposed requirement in relation to joining the race or the election. So would you not consider that unauthorized works? Do you think this is unauthorized works on the basic law in Article 104? If so, is there a way to remove such unauthorized works? Interpretation of Article 104 of the Basic Law. That's in accordance with Article 158, Paragraph 1 of the Basic Law. The NPCSC also published explanations on the interpretation to give the background and the basis for that interpretation. So when the NPCSC made the interpretation, it has considered relevant circumstances. Now, I'm not asking about the procedure, Secretary. There are many in the legal profession who said that this is supposedly an article to do with oath-taking after someone has won an election, but now you have imposed a requirement here which has to do with someone qualification for running in the election. So is that unauthorized works? If it is, is there any way to remove it? Secretary. Now, if you read the explanations of the interpretation, there are public officers listed in the provision, and so it's on that basis that the interpretation was made. No, my question is it the case that the NPCSC could add unauthorized works on any articles of the Basic Law through interpretation, yes or no? Secretary, I'm sorry, it's not simple yes or no. Because the NPCSC has to have regard to relevant considerations, and is in accordance with Article 158, Paragraph 1 of the Basic Law. Mr. Felix Chung. Political accountability system is designed to allow people from outside the civil service to take up political offices. So it would like someone, say, from the business sector to join the government. Ms. Teresa Zhang is a senior counsel. She decided to give up her practice and joined the principal officials team. I'd say it's not an easy decision. Well, she came from outside the government. She doesn't know about how hot this kitchen is. So when it comes to handling her personal issues, she did handle it rather poorly. Now, as the Secretary for Justice, the public expect her to be fair and impartial in dealing with legal issues in future. So my question for the Secretary is this. Now you handle your personal issues rather unsatisfactorily. In future, there will be various contentious legal issues to be dealt with. How can you prove that you're able to be a good gatekeeper for the rule of law in Hong Kong? Secretary, yes, there is much room for improvement in the way I handled the case. I hope that I have learned my lessons, and then when I do perform my duties as the Secretary for Justice, I can do even better. Now, as I perform my duties as the Secretary for Justice, will always have regard to the law, and I'll be fair and impartial in handling all matters. So you can believe that I will certainly do so. Mr. Chung. Other members talk about integrity. Secretary, yes, you asked us to believe in you, but you need to show us examples. And so we can believe in you. We need to address your integrity issue.
Secretary, Chairman, Member, here I can only say that I will do my best to do what I have to do in the best way possible. Well, in my private practice, I have accumulated knowledge and experience. I hope this can be shown in my future public work. Mr. Holden Chow, thank you. Madam Chair, Secretary, we have wanted you to come here, to come and give a full account of your unauthorized building works issue. I hope you have learned the lesson and not allow this to affect your work at the DOJ. I hope you will regain the public's confidence in you. This is what we expect you to do. Today, many members mentioned the disqualification of Agnes Chow. I'd like to state my own view here. Actually, Agnes Chow represents Demo Sisto. It has always advocated self-determination. It doesn't talk about Hong Kong independence, but covertly, it is asking Hong Kong people to choose to make Hong Kong or separate Hong Kong from the country. So how can you ask people to believe that you genuinely and truly swear allegiance to Hong Kong SAR and uphold the basic law? You are talking about separating Hong Kong and the country. Therefore, I think the disqualification is founded. This is my own view. My question for the Secretary is about her legal work. I have asked an oral question in Council before, and this is about class action by consumers. Starting from 2011, the LRC mentioned that already, and in the last few years, many meetings have been held. But all along, society has not been briefed on the progress. Secretary, can you take the opportunity to let us know about when you will let us know whether any progress has been achieved? I am talking about class action by consumers. I think we need to discuss this with society. This will not harm our business environment. I'm only talking about class action by consumers. Please, Secretary. Secretary. Thank you, member, for the question, and I have heard his comment. Class action by consumers. We hope to use it as a pilot in order to launch class action. But when we discussed it, we found that this was intertwined with a series of other issues. The working group has not been able to solve all the issues so far, but that is the right direction to take. Class action by consumers will be the pilot because it will take care of legal costs that may be a problem for the general public. If there can be class action to tackle consumers' collective worries, that is the right direction to take. The DOJ knows that this will have to be arranged as a pilot. Ms. Eunice Yong. Madam Chair, I'd like to ask about farming out of criminal cases. I understand that junior bar members who have fewer than 5 years of experience choose to undergo training that you conduct together with the Bar Association or the Law Society. I have heard that they will have 1 or 2 days work in a month, and then in the next month they will have no work. Is it possible that at the High Court and the District Court you can give opportunities for the junior bar members to work alongside senior bar members so they can get more experience instead of waiting 8 to 10 years to go to a district court and to wait for more than 15 years to go to the High Court? It is important that they be given the opportunity to accumulate the experience. Will there be this possibility of review about a criminal case farming out? Secretary, I really thank this question. I think it's an excellent proposal. We understand that in the bar system, a barrister who has just been admitted will learn from a senior barrister by working alongside that senior bar member. So this junior bar member will be able to advance in his work as a barrister. So the member's proposal will be taken back to the DOJ for consideration. I hope that I can use this opportunity to communicate with members and the legal sector so that you can Let us know your thoughts so that we can even do better at the DOJ. Thank you, Mr. James Toh. Madam Chair, I'd like to ask the Secretary when it was the first instance she knew about the UBW in her Tuen Mun house. Secretary. Thank you, Mr. Toh, for your question. I was not particularly aware of the UBW at Tuen Mun. I bought it on an as-is basis. I did not really take a look when I moved out. When was the first instance? The first time, was it the 5th of January? Secretary, as I said, as the owner. No, Secretary, answer the question. When was it the first instance that you were aware of UBWs in your Tuen Mun home? On the 5th of January, I received the notice from the buildings department. I immediately engaged an AP to do the inspection. Was the 5th of January the first instance that you knew about it? Was the 5th of January the first instance? She answered the question. No, she did not answer. Was the 5th of January the first instance you knew about the UBWs? When I bought the property, I bought it on an as-is basis. Was the 5th of January the first instance you knew about it? At that time, indeed, there was a basement already. And I moved in. I did not ask any authorized person to do any inspection. My question is, Secretary, you are saying that actually when you bought the property, you knew already about the basement. But you are saying you did not ask an AP to do the inspection, so you knew about it only on the 5th of January this year? Secretary, when I bought it, there was a basement. At that time, I did not pay particular attention to it. What about the rooftop structure? I moved in, and I never thought of engaging an AP to do any inspection or to deal with it in any way. As the owner of the property, it must be for me to take up responsibility, and that is why I engaged an AP and I wasted no time in doing it. Secretary, some members asked you, it was 9 years ago when you signed the deeds. There was no basement that was mentioned in the deeds. You lived there for 9 years, and you did not know that it was an unauthorized building work. Given your background and your professional knowledge, don't you think it is quite unimaginable? Secretary, Madam Chair, I already said part of what I wanted to say. Perhaps I should continue. No, Secretary, you are now at the Legislative Council. When members ask you questions on behalf of the public, please do not read from a script. It is not that when you have the determination to serve, you can also have the determination to read from a script. Are you telling us that given your professional background, you knew that there was no basement when you signed the deeds? Does it mean that throughout these 9 years you did not know that there was a UBW? Secretary, please be brief. As the owner, I have to take up the relevant legal responsibility. So when the buildings department asked me to rectify, I did so in the first instance. It doesn't serve any purpose by just reading from a script. Well, it's no use for you to ask more questions. Reading a script doesn't mean you can carry on with your work. I will have to announce that I have to extend the meeting by 15 minutes in order to process 2 motions. Last 2 members, Dr. Cheng Chung Tai. Thank you, Madam Chair. I'm not a member of the panel. Thank you for allowing me to speak. Secretary, when integrity checking was done, you told the CE that you were still working on 6 arbitration cases. You say the final submissions have been made for these cases. I'd like to ask the Secretary, in that process, you disclosed the 6 cases to the CE in the process. Whether you talked about the names of the people or details of the case, I think that would fly against legal principles as we know them. Secretary, was it against legal principles? I needed to tell the CE and ask for permission to allow me to finish off the 6 cases. And they were in a unique situation, as I said, because the substantive hearings had been conducted, and both parties had already submitted final submissions. There were 3 arbitrators at these hearings. In some I was the chief arbitrator, in some I was the co-arbitrator. So these cases were almost completed, and that is why I said I would hope to be able to complete them. So I had to notify the chief executive. No, Madam Chair, so you disclosed the information. You said clearly in documents that these 6 cases had nothing to do with the government or the work of the DOJ, but as a layman who have little knowledge of the law, so you actually disclosed the people involved in those 6 cases to the CE. I did say something about the 6 cases. No, I'm asking her. The problem with her being the S for J is not just about the UBWs. Of course, she breached the law knowingly with regard to the UBWs. But then she is now only a half-time S for J because she is having a part-time job. That will deal the biggest blow to Hong Kong's rule of law. You say the 6 cases have reached the stage of final submissions. Are you saying that you would certainly be able to win those cases, or would you not be able to win those cases? Secretary, perhaps I did not make myself clear just now. In those cases, I am not a lawyer of any party. I am the arbitrator, meaning both parties would make the submissions, and I have to make a ruling on which party will win the case. So, Madam Chair, this is exactly what I want to point out. On the one hand, she is the S for J, but there is this duplication of roles and powers. By so doing, she has damaged the rule of law. Last member, Mr. Shu Ka-fai. Thank you, Madam Chair. Hong Kong is an important member of Belt and Road and also the ASEAN. Tax considerations and laws are involved. As the S for J, I'd like to ask the DOJ what it can do about international laws. And do you have enough people at the DOJ to work on international laws? Do you need more resources? Because I like to look at the economic side of things. Secretary, thank you. Chairman, thank you. Member, for your question. When Hong Kong develops its economy, we need to enter into bilateral or multilateral business and investment agreements. In the policy address of 2017, the CE said that the Hong Kong SAR would sign more such agreements on free trade or protection of investment. This will help the business sector to develop. Here, I'd like to thank this panel. At its meeting last week, the panel approved the creation of a post at the DOJ to deal with international laws. This will allow us to deal with international laws so that we can do our work in negotiating bilateral or multilateral agreements on taxation or on investor protection. I'd like to take the opportunity for thanking the chair and also members for approving the creation of a post required by the DOJ. This is an important creation of posts, and I hope you will continue to support us. But 100-odd countries are involved with regard to the Belt and Road Initiative and also ASEAN. Mr. Edward Yao, of course, is visiting the countries, but I think the DOJ should also be visiting these countries. How can you deal with 100-odd countries by creating just one post? Because you are dealing with very different legal systems. Secretary, I thank the member for being so considerate about our manpower situation.
We will try to do our best. If we need to come back to the council to ask for a creation of posts, I hope then we could give detailed explanations then. Now, I would say that I do not rule out this need for bilateral agreements, and as the member pointed out, we need to deal with far more countries than we had imagined. Now, about the business laws in the reference place or the business environment and so on, we need to have better understanding, and that's in line of Hong Kong's interest. Now, more than 30 members have asked questions. Tabled before you members, there are 2 motions. There's one with the number 1 at the top right-hand corner that's moved by Mr. Dennis Kwok and seconded by Mr. Alvin Young. It's on the question of disqualification, and also is about the performance of the Secretary for Justice. The second motion is moved by Mr. Alvin Young and seconded by Mr. Dennis Kwok. That's number 2 at the top right-hand corner. It's about the UBWs of the SJ. It's about whether the SJ should is a suitable person to stay as the SJ. Now, for both motions, they have been submitted to the panel before the meeting. Now, these are, I consider these motions relevant, so I suggest that we go straight to the vote. Yes, Mr. Alvin Young? Madam Chair, can I confirm that we still have 50 minutes for this meeting? We have just 10 minutes left. So there's enough time for a division, right? Yes, there's enough time for a division, and we have checked with the Secretariat. We could claim division, but we don't need to wait for 5 minutes. We can just press the button. If members of the panel are already here, you can just take a look, and then there's no need to ring the bell, right? I think it's fine if we read out the motion. Yes, I'll let you read out the motion, but I must remind members that only members of the panel may vote, and there's no need to ring the bell for 5 minutes. We could proceed straight to the vote. First, the motion of Mr. Dennis Kwok. Do you need to read it out, please, quickly? Do so quickly. My motion is already tabled. I don't need to read it out. But I would like a claim of division. So, Mr. Alvin Young, do you wish to read out your motion? Yes, I do. Okay. Then the new Secretary for Justice covered up on many UBWs and property sales and purchase issues, and she delayed giving an explanation to the Legislative Council. This panel has expressed its great regret about her integrity, professional judgment, and performance as the SJ. We believe she is not a suitable person as the SJ, so we now move a motion of no confidence. We move a vote of no confidence in her. Okay, so there's no need to ring the bell, and now we could proceed to vote. Please press the reference button. So we will first vote on motion 1, the one moved by Mr. Dennis Kwok. Isn't it better to read out the motion? Mr. Dennis Kwok, could you please read out your motion? The Secretary for Justice disregards the conflict of role in the oath-taking case and the by-election. She rendered mistaken legal advice to the returning officer. So at the end, the returning officer disqualified candidate that's denying Hong Kong people of the protection under the Hong Kong Bill of Rights. And this panel is would like to make a vote of no confidence in the unprofessional performance of the Secretary for Justice. Okay, can we vote? Are there any questions? No, then voting is closed. We're talking about motion 1. 17 present, 7 for, 10 against, no abstention. The motion is negatived. Next motion, moved by Mr. Alvin Young and seconded by Mr. Dennis Kwok. If you're ready and the system is ready, then please proceed to vote. Please check your votes, members. If you already voted, I now declare voting closed. Results will be displayed. 6 for, 9 against, 1 abstention. Yes? You didn't press the button? Okay. We can just record that you voted for this motion. Okay? So we just put it on record that Mr. Danscroft voted for this motion. The motion is again negatived. So we've completed the agenda today. We hope that the Secretary for Justice would have more exchanges and with this panel, and you would come and answer members' questions. Now, there are several issues raised today. I have agreed that they will be taken up at a future panel meeting. So, DFJ, please prepare the necessary materials. Thank you very much for coming to the meeting.